Hold on right there. I see what you just did. You need a contract, so you asked your buddy for a copy of hers, or you downloaded one from some buy a contract place. Who knew? I guess there are contract stores all around. Or you went online to Reddit or somewhere else and found something that looked pretty good. Oh, it's got big words in it. It's got whereas and forthwith. So you just copied that and used that for your contract. Well, everybody wants to save some money. I understand why you're doing it, but there's no substitute for real legal advice. Let me give you the top 5 mistakes that I see people making in these borrowed, stolen, contract factory sort of contracts. Check yours and make sure you haven't screwed this up, because these 5 things will cost you a lot of money if you don't know about them. Better yet, go see a real lawyer and have them review it. And get a lawyer licensed in your state, not your high school buddy who's now practicing in New York and you live in California. Get a lawyer, a business lawyer who does this all the time, licensed in your state, and run your stuff by her. Okay, first thing, choice of law and venue. Venue means where you're going to go to court. It's specified by state and county. This is because if you want somewhere close to you, you want somewhere that your attorney knows the local rules, because every court has different rules. Specify the venue, the county and state in which any action has to be brought. That way, if you live in Florida, you don't end up getting sued in Michigan, have to hire local counsel up there and travel up there. Just make it part of your contract. Choice of law means which state's law are you going to apply to interpreting the contract? Believe it or not, there are a lot of differences state to state in how something is interpreted. For starters, there's a mailbox rule that says an offer, an acceptance of an offer is effective the moment it's deposited in the mail, except in certain states. So this is the other risk to use a local attorney. You need to know what choice of law issues can arise. You grab a contract from Pennsylvania and use it in a California contract when you want to be in the district in the county of Los Angeles, you're hosed. If you borrowed something, go check and see if the venue and choice of law clause makes sense to you. Next one, single member LLC. I know you've heard all these seminars on why you need an LLC and how that will protect you completely. But did you know that each state is a little bit different in how it treats LLCs? An LLC is not a national sort of critter. It's a state entity. So how each state administers theirs varies. For instance, in some states, a single member LLC is pretty much ironclad. In other states, if there's only one member in the LLC, historically and by case law, it is a lot easier to pierce that corporate veil that you've been counting on and come after your assets personally. Check and see how your state treats single member LLCs. Now, other states will even allow a charging order against an LLC and your personal assets. So you can't make a mistake on this. If you have a single member LLC, check and see how your state treats that, if it's any different from a multi-member LLC. Third problem, arbitration. Does your contract allow for it? Does it require it? Is it binding or non-binding? Can you take a binding arbitration judgment into your local court and get it ordered to execute? Is there another step to it? All this depends on your local rules and your state law. Check and see if you have an arbitration clause, see if it's binding or non-binding, and find out how your state treats those results of an arbitration, whether or not they can sue you or whether or not the opponent is bound by that decision. Oh, what else here? Oh, this is one of my favorites. You're going to love this. This is such a useful tool. Liquidated damages. I'll say that again. Liquidated damages. This means that you and the other party to the contract agree ahead of time what a breach is worth. A for instance, rather than, say you're doing a contract for a website, okay? And the website never gets finished. Well, whoever you were building it for may try to sue you to get their money back, to get damages that result from loss of business. Issue there is to whether it's a new business or an ongoing business, so watch out for that. All sorts of things. Liquidated damages just says, hey, in the event that there's a breach of contract by either side, we agree in advance that returning your money is a sufficient and fair estimation of the damage, and we agree to those liquidated damages. You agree ahead of time what a breach of contract might cost. Makes sense, doesn't it? You don't want to get into one of these crazy things where everybody's suing you for millions of dollars of lost revenue and they want to prove it up, because let's face it, even if you win, you lose. All that time and money spent on a court case, all that mental stress of being sued, you don't need that. Agree to liquidated damages. You can enforce that in court if you need to, depending on your state law. Finally, this is the big thing. This is the big thing. People get involved in a breach of contract case where one of you screws up. And suppose somebody's done you wrong in the contract. You hire a lawyer, you go after him, you sue to recover your damages. Guess what? The amount of money you spent on attorney's fees is not a recoverable damage that you've suffered as a result of the contract. It's just not, unless there is a clause in your contract that says the prevailing party is entitled to reasonable attorney's fees. Normally, you won't get unreasonable attorney's fees, but you can recover your costs that way. See if you have a clause that allows you to recover attorney's fees in the event that you prevail. Note, in California, there must be a citation of the specific code and a particular way that you word it. Again, another reason why you want to be involved with a local attorney. In that award of attorney's fees, the clause will normally say the prevailing party is entitled to attorney's fees. So what is the prevailing party? Who is the prevailing party, I guess I should say? Is it the party who wins at court? Is it the person who is the victor in an arbitration? Is it the party who signs off on a settlement agreement? There are lots of definitions of prevailing party, and you want to make sure you understand what that means in your state or that you have to find in your contract. So the 5 things: venue and choice of law, single member LLC, arbitration, liquidated damages, and finally, attorney's fees as part of your damages. Check those 5 things in any contract you swipe through somewhere. There are other things as well, but start with those 5. Hope that helps.
For more information on making the law work for you and on being a citizen activist, come on over to sinmobleylaw.com. Let's talk.